Washington. Amidst legal problems faced by former President Donald Trump in the federal and state courts, efforts to exclude him from pre-election and general election votes under a little-known provision of Constitution are of interest in many states. Legal proceedings. Known as disqualification 14. It refers its article, and this provision is currently quoted by voters in Colorado and Minnesota in 2 cases claiming that Trump is not constitutionally eligible to perform federal office due his actions. Lawsuits targeting former president will test scope and strength of a constitutional provision that came into force after Civil War. It led to legal struggles that were sure to be closely monitored. And if Trump is currently a candidate, results may upset Republicans pre-election. It was determined that leading candidate GOP nomination was not eligible to run for White House. Third time. 14 of the U.S. Constitution. What does the department say? Also known as disqualification provision 14. The section states no one who has previously sworn in as member can be a senator, representative in Congress, voter of the president and vice president. Any civilian military within the United States, any state cannot be on duty against to support United States Constitution a congressman, an officer, a member of any state legislature, an executive judicial officer, any state it will have entered uprising, rebellion, likewise, or to give help or comfort to their enemies. However, Congress can remove this obstacle by voting for 2/3 of each assembly. This provision will apply to those who have sworn to support U.S. Constitution and attended uprising, rebellion, or assisted comforted enemies of nation against United States. Chapter 3 allows Congress to remove such obstacles with the House of Representatives and the Senate's 2/3 vote. Why did it become law? The amendment was adopted by Congress in 1866 and approved by the states in 1868. The disqualification clause, which came into force after the Civil War, aimed to prevent former Confederate civil and military officers from staying in state or federal office. Has Chapter 3 been used before? According to National Archives Records Administration, Chapter 3 was mainly used in period between approval of Amnesty Act and its entry into force in 1872, which lifted ban on serving for most Confederate officials sympathizers. Confederate General Robert E. by Congress Lee and former President the Confederate States of America, Jefferson Davis, were also granted exemption after the death. Chapter 3 when full citizenship rights were returned in 1975 and 1978, respectively. According to the 2021 Law Review article by law professor Gerard Maglioka, who thoroughly examined this provision at Indiana University, a 1869 case involving Caesar Griffin, a black criminal accused. 3. It is considered the first major judicial opinion regarding the department. In this case, Chief Judge Salmon Chase, who served as a district judge